I lied. Here comes another one. Krista and I talked a little bit, and we thought that it might be a good idea to start out with some administrative stuff and some updates pretty quickly. And I'll start with that, and then we'll go into the substance of the conversation today. First, I want to say thanks to Scott Healy for being here today. He's with, I think, Clackamas County. And he's covering for Bill Golden, who's out today. So just want to make sure everyone saw that we had a new face today. I wanted to give you a quick update on a couple of the small groups. The small group appeals group, which was the one that was Judge Brisbane, Jim Nass, Jimmy Brewer, Paul Smith, and I know I'm forgetting somebody. I apologize. They're going to meet next week to talk about some language that Jimmy and Paul have pulled together. So that is where that one is. That was the question about scope and retaining and remanding appeals. The conversation around default judgments, we have the conversation still ongoing on that. And I think that I understand that some people are out on vacation. So we're going to circle back when people are back from vacation. There were 2 sets of questions that were sent out. I've got another one. Hold on a second. Double check to make sure I'm not missing anyone. 2 sets of questions that were sent out. One had to do with outstanding questions that were kind of we needed to answer in order to write working draft 4 which Jessica and Victor are working on. And if you have any feedback on those questions, can you please let us know by Sunday of this week, which is June 30th, I think. And then I would also flag that we sent out some questions regarding things that we thought were close to consensus or, oh, I've got another one on here. Sorry, it's distracting. That we sent out, we've gotten some feedback on those questions as well. But if you have feedback on those, please let us know so we can incorporate that into the drafting process as well. Krista, was there anything else that we were going to flag on the front end?
I can't think of anything right now. And I just want to say I appreciate those of you who are putting in a lot of extra hours right now to hammer out some of the more difficult provisions or unresolved ones, and also those who have given feedback on the questions that we thought we knew the answers to, and maybe or maybe not. But please get us your feedback as soon as you can, so that Jessica can continue the detailed work of getting our next working draft done. Was there anything else you wanted to say, Amy? Okay.
I think that's it for now.
So on our agenda today, the first thing we have is the small claims discussion that we have now put off twice. And so I want to start there and definitely get through that before we get into anything else. So looking at the broad ideas of what, and again, thank you, Jim, for putting together the proposal for us to have something to work off of here. The broad ideas, I think, are rewording some of the current language to make it more understandable, and we can go through this more specific wording here. But secondly, adopting the procedure that we have in our working draft number 3 for most of this. So adopting the procedure in sections 7 through 13, 14, 24 through 29. And I guess that's where I'd like to start, is to see if that's sort of what everyone is thinking is a good idea here. And I think I'd like to try the polling that we did last time and see if that's helpful here too. So I guess first of all, and for anyone who wasn't here last time, what we were doing was this is an informal poll asking you to just sort of raise your hand if you agree with or disagree with whatever the question is, to get a sense of the group. And it's not a vote, it's just to try to launch our discussion here and see where we're at with consensus and where we're not. So as far as the question about adopting the procedure in sections 7 through 13, 14, and 24 through 29 of Working Draft 3, is anyone opposed to that general concept? Okay, we have one person. Judge Cross, you want to talk about that?
Well, that's a very broad spectrum. I'm still missing, for example, until Jim told me last week that chapter 1, we were going to just repeal chapter 157. I saw nowhere in the working draft that said it was going to be repealed. And then when I see, he said, and it's going to be replaced by what's in section 7, subsection 2, but that just is provided in sections blank through blank of this act. I think we're a little, I think we're a little lack of definition away from being consensus on saying we're done.
So it's the Working Draft 3 doesn't show all of the sections that are being modified or repealed as you've noted, and the next draft will show that, so it might be more clear then. But the notes that Justice Duncan put in the comments to the working draft show where the different provisions are being incorporated from and where the language is coming from. And so section 157 is largely incorporated in there with the changes that we've been working on this whole time to wording.
And when I responded to Jim, I said, yes, I assume they're going to be, you're simply moving some of these things, not just getting rid of them. But my point is, the commentary on the side is not necessarily what has been agreed upon or put into the text or the working draft. So anyhow, I think, Brandon, my overall impression, we spent a lot of time at the front of this project, maybe involved in some discussions that were not really terribly on point to the overall purpose, and now we're getting very rushed, and I think that's a recipe for potentially making some mistakes.
I appreciate the concern about being rushed, and we don't want to rush through anything and make mistakes, for sure. It is a compacted timeline. However, we have been working on this for the past year and on this language. And so I think that if there's specific points that where you think that the current provisions are not adequately incorporated, or that we haven't adequately discussed the changes, then it would be helpful to receive that feedback. Justice Kidd?
Yeah, forgive me if this has already been addressed, but I sent an email I think last week around the one draft had appeals for justice courts that had become courts of record still being de novo, and I don't think that makes sense. I think that appeals for justice courts that are courts of record should run, to the extent there is an appeal, a small claim, it should run the same way as it runs in circuit court.
Is that something that we addressed as a typo in the past, or I'm not quite sure, because I think that we're not trying to change that. So if there's a typo that we haven't rectified yet, then
I think it's less of a typo and more that current law is simply silent on what the status of a small claims court judgment from a justice court of record. And it's actually the first section of the amendments that you're looking at now, subsection 3, was an attempt to clarify that a party could appeal from a small claims judgment in a circuit court of record, but that the appeal would go to circuit court. Judge Kidd makes a valid point, because justice courts of record are now of record, and because the law requires that the judge of a court of record be an attorney admitted to the practice of law, that a justice court of record small claims department should be treated the same as the small claims court judgment of a circuit court and should be final, and that there should be no appeal from it.
So I think Justice Kidd, I didn't understand your initial comment. Were you just talking about the small claims provisions specifically?
Yes.
Okay. I missed that at the beginning of your comment. So other discussion around that particular issue?
Krista? Just
Just
a for clarification. So Jim, are you saying in the circulated materials regarding small claims that in subsection 3, should we delete regardless of whether the justice court is a court of record?
Either delete it or rephrase it to make clear that there is no appeal from a small claims court judgment in a justice court of record, one or the other.
Okay. Thank you.
Justice Brisbane?
I agree with Judge Kidd's comments, and the changes need to be made to subsection 3.
Any other discussion on that? Okay, so as I understand it, the proposal is just to delete that phrase regardless of whether the justice court is a court of record?
No.
I'm gonna have to yield to Jessica as to how to communicate the thought. I think current law is not clear what the status of a judgment rendered in the small claims department of a justice court of record. So I think we need to address its status, whether you can appeal from it or whether you can't. So I think what I would probably prefer is rephrasing subsection 3 to make clear that you can't appeal from the small claims department of a justice court of record.
Justice Kidd?
So what I think might be even clearer is if we could just insert a provision that says that for justice courts to become courts of record, appeals in all manner of cases proceed as if they were in the circuit court. Because the reason that we have this weird appellate structure is that we're not courts of record, but there's no reason, and in fact, historically, when there were district courts and justice courts, appeals could run the same way. So my proposal is we just put in there somewhere, if we are a court of record, that appeals run just the same as the circuit court appeals for all manner of cases.
Any discussion of that?
That kind of worries me. It ends up being awfully vague, and then requires the reader to go search chapter 19 to find out how you appeal from. Actually, chapter 19 to find out how you appeal from civil cases, and chapter 138 to find out how you appeal from misdemeanors and violations. Since chapter 55 deals with small claims in justice court, I think I would prefer that at least we make it clear here that no appeal lies from the small claims department of a justice court of record.
Jim, which is the same for circuit court, right?
Yes,
You're in the circuit court, small claims department, no appeal. And you would be saying justice court, small claims, no justice court of record, no appeal.
yes.
And perhaps an issue with sending folks or having a general provision, sending people to 19 with it, when we're talking about small claims, would suggest you could appeal from a justice court of record. And you can't in small claims.
Yeah, actually, to correct myself, it would require the reader then to go look at the chapter on circuit court, small claims department, to determine that no appeal can be taken. And to me, it just makes sense to put it in chapter 55, because that's where the reader already is.
And we do have general provisions in other places, 19 and I think 138, that say if you're of record, court of record, then you just go like you do out of circuit court. We've got those Justice Kidd in those other chapters. I think here we just have that special problem with, or special situation with small claims where there's no appeal. And that's perhaps the thinking of having a special provision here.
I'm convinced.
Okay, let's, I guess, do you want to state the specific proposal, Jim, and we can just take a hand poll to see if there's anyone opposed to it?
I would amend ORS 55.110 the new proposed subsection 3 to read along the lines of no appeal may be taken from the small claims department of a justice court of record. Something like that.
Something like that, to be finessed potentially by Jessica. Does anyone oppose that? Okay, wonderful. Thank you. Let's move on to the next question. So I guess, does it, there are some new provisions that Jim added in here, with the intent that the same requirements that are enacted for other appeals from justice and municipal courts will apply to, and some of these remain to be determined, namely appealability of default judgments. That would be the same, whatever is decided for the court in general would be the same for small claims. Does anyone have any comments on any reason it should be different?
I just echo my previous concern that, and it's even more magnified in the civil department or departments where it's private parties who are acting as plaintiffs, that if we create a default structure that makes us a bad place for plaintiffs to file, then plaintiffs will not file here. And so that further burdens the circuit court. So I think it's important in both sections, but I think it's even more important in the sections where we have private parties who are the plaintiffs.
So it sounds like you're advocating that it be the same as what is decided, which you have a particular position on, and the work is ongoing to figure that out, and we're not going to try to resolve it in this meeting. Is that correct?
Well, I guess what I would say is if the decision is on the violations cases that the appeals be cabined, then I think that it should be the same. If further though, if the decision is on the violations department that for some reason there is some sort of de novo appeal of a default, it should be different because it's even more important to private parties that they have some finality. Right. So for example, if you were to be a landlord in the civil division running an FED case, and you go all the way through the process and you get 6 weeks in, because the process can take quite a long time, and you get to the day before the sheriff comes out, and then somebody appeals their default, and you start all over in circuit court, you would never ever file again in justice court. So I think particularly in some of the civil cases, it makes extra sense. So that's my position.
So, so the text as is subsection 2 in Jim's proposed draft, does anyone have an objection to that? Okay, then we'll tentatively leave that as is. Minimum amount of in controversy, I think we previously decided that we're not that we're not changing the $30, and we were gonna make it the same for or I guess that's what's already in the small claims provisions, is that right? Or is that different? Sorry. Is that a new provision to add the $30 minimum?
No, that is in current law.
Okay,
One of the things that struck me about the existing language in ORS 55.110 sub 2, it says appeal shall be allowed as provided by law for other cases. And I went, well, what does that mean? And I assume it means in other civil cases. And the only limits I could find on appeal that's applicable to civil cases generally is no appeal from a default judgment and the $30 amount in controversy. So I simply restated those so that readers don't have to go look elsewhere to find out what those limitations are.
any discussion and further discussion of subsection 2B in Jim's draft?
Not there, but I forgot something on sub 1, if we could go back in a minute, once we're done with this.
All right, so anything else on 2B? Okay, sounds like we've got consensus on that. Judge Cross, what did you have?
We're on 55.110 sub 1. Taking away the 10-day, that's right, but right now there's no other timeline put in there. And I think we need to put 30 days in there as a timeline to file.
The reason that there's no time stated is because down in the next section 55.120, the statement that the appeal from the small claims court department shall be the same as in section 7 through 13, so on and so forth. It's in those sections that you'll find the 30-day appeal period. So basically what we're saying is that the same appeal time that applies to all other cases in justice court also now apply to small claims court cases.
I missed that connection, Jim. I'm sorry. That's fine now.
No, it is certainly not obvious.
Thanks for that clarification. Okay, the next big picture question is the mandate for whether we should have a form notice of appeal in the statute, or instead have a mandate that a form notice of appeal be created either by OJD or I suppose the justice courts. And in current statute, there is a form notice of appeal. So the question is whether we should take out that form and or revise it, or put in a different provision that says that another entity should create a form. Any comments on that? Judge Britton.
I am not a fan of forms being in statute, because if you want to change the form, you have to go back to the legislature, and it's just not as flexible. We still have things in statute that talk about like facsimiles, which nobody uses. So I definitely don't think it should be in statute. I think we should delegate to an entity to create the form. OJD seems like the most logical place.
Tony?
Yeah, thanks. I think you can always say substantially in the form, you know, of the one that's set forth in the statute. And I think then that gives enough wiggle room for the courts to modify it as needed. It's just a suggestion.
And I think the other option would be to list certain things that need to be in the form. That would be another way to do it. Justice Brisbane.
Okay, thank you. I agree with Tony that we should have a form, and it could say the appeal from the small claims department may be in substantially the following form. That gives the local court the option of modifying it slightly for the local county's need. If we don't do that, then we would like to have OJD draft a form, but we definitely need a form that's consistent so that, for example, in my county, we have a dozen municipal and one justice court that could potentially file appeals, and it would be good to have a form that we can point to for the appellant to use.
Lindsay?
I'm trying to remember, did we decide that there would be a form for the other types of appeals to circuit court, like violation and misdemeanor appeals? I just don't recall where we landed on whether or not there would be a directive to either OJD or someone else to create that.
I think this is among the list of questions that we thought we had an answer to, but never formally got a decision. It was my impression that we were heading that direction in our group discussion, but open for comments at this point. Lindsay, actually, if it might be helpful if you would talk about how OJD does the forms and how that works for the local courts in general. Do people revise those forms when OJD does a sample? How does that work?
Yeah, so usually there would be it's not uncommon for there to be a directive in statute for OJD or the state court administrator to develop a form for whatever the document is. So sometimes it's just the state court administrator, sometimes it's in consultation with other entities. So that's not uncommon to see it, and usually it would just be that, and maybe with requirements for some of the contents, but that we would just develop the form or come up with what that should be. And then we have, a forms part of our website where folks can find all of those statutorily mandated forms.
And that doesn't necessarily mean that each local court is required to use the form. It's something that's available for them to use, right? Unless, I suppose, if we put in the statute that somebody had to use a form, that would be the question.
That's right. I think it depends on the statutory requirements, but I think that would be right. And if there's statutory requirements for what needs to be in one, then if someone used their own, they would still have to make sure to include the required information.
Melissa?
Yes, thank you. And I know this issue was raised several meetings ago, but I would just echo the comments by Judge Britton, as well as just my experience with OJD. There's a lot of good people that are tracking legislation every year, and a lot of good people that are doing forms over there. And I think they're just better equipped as a central unit to follow the legislation. So I'm not saying that these appeal statutes are going to be touched every year, but if there is someone that is keeping an eye on it, OJD certainly is. And I'm also not saying that the local courts aren't following legislation, but in the event that courts don't have the ability to follow legislation, OJD is on top of it and usually release forms pretty quickly following legislation when it goes into effect. And so I would just say I think that they are the best entity, and I also hate seeing forms in statute. I agree that they look a little messy. And the other thing I would mention is there are already mandates regarding local courts to use statewide forms such as the DUII forms. I am aware that some local courts don't necessarily follow the statewide forms that are actually have to be approved by the Supreme Court anytime they're changed. So I think even mandating may not do as much as we think it does, but I'm just here to be a proponent of the forms run by OJD. Thanks.
Judge Cross?
About 20 years ago, I sat on the on Chief Dominguez's Criminal Justice Advisory Committee and was on a subcommittee tasked with bringing a standard plea petition for the entire state of Oregon. And we worked long and hard on that thing. It was put together. We came up with a product that everybody was satisfied with. The entire committee loved, and it was employed by about 3 counties. So unless there's a requirement that every county use the OJD form, I'm not so sure that it would accomplish the goal here, such as having it in the statute saying that you must have this document which substantially complies with this form. I'm just saying, Mike, it's like herding cats to get people to accept a form that everybody on the committee thought was fantastic.
I'd like to see, actually, Jessica, do you have some comments about how it's sort of what the trends are in legislative drafting at this point?
Yes. So we do regularly put forms in statute. I would say it's not necessarily favored. I don't want to imply that our office like won't do it or that we advise against doing it. It does create some complications with our drafting software, especially when we need to modify it in the future. So I say it's like maybe generally disfavored, but I again, I don't want to imply that our office will not do it if that's what the group decides.
And are there, I guess, do you know, are there many other sample forms in statute at this point, or are they mostly being directed to be done by OJD?
I've seen a lot in statute, but again, I don't think I really have a sense of what the numbers are compared to just a general directive versus a form. I would say, I mean, I only deal with the criminal code and a couple of chapters outside the criminal code. And I would say there's probably more directives, general directives than there are specific forms. But I know that when I'm working in other chapters that have more to do with civil proceedings, then I do see a lot of forms.
Jordan?
Thank you. I wonder if it would make sense to do or craft language that says each county has to use the same form within the county. Judge Cross's story about plea petitions rings true for traveling between counties with criminal cases, but I think generally speaking, the counties each use the same form for that. So I don't know if we could do something along those lines.
Justice Kidd?
So as far as I know, the municipal courts don't have small claims or civil jurisdictions. So in every county except for Douglas County, there's just one justice court. So there's only one court in each county anyway who's going to be doing at least this little chapter.
Justice Brisbane?
Well, now we've gone back to talking about whether there'll be an appeal form for violations and also for small claims. I'd be fine with directing OJD to keep a form in their form center that could be used. But when you have over a dozen local courts in one county, you're not going to get the same form unless it's directed that they use the state form.
And after hearing the discussion about possibilities like including some particular things that have to be in the form, does that change your thoughts about whether it's important to have an actual form in the statute or not?
Are you asking me?
Yes.
I don't care if it's in the statute or if it's at the OJD Form Center, which is an excellent resource. I just would like to see a form that's used statewide.
So you would want to mandate in the statute that,
One way or the other, we need a form that's consistent. Because circuit court, when they have to deal with, so for example, in Clackamas County, there's a dozen courts. And if they have to deal with a different form from every court, it's not that easy for them to process the cases. If it was consistent, it would be better. And I'm talking about violations and right now, but we should make it the same for the civil documents and the violations appeal documents.
any other comments or people that would like to put out a proposal?
Well, I guess I would just like to make clear that I don't think anybody favors mandating a form that would be a mandate for the individual party, because then that puts the burden on the circuit court to review that form and possibly to dismiss the appeal if it's not in exactly that form. I think the best we can do is design a form that provides all of the information that the circuit court needs to set up the case. Make that form available to parties who choose to use it. I think that's the most we can do.
Linda?
I have Lindsay on here, so she may jump in for me, but I support the OJD doing the form. It's consistent. Every court's going to get the same thing. I can just see courts struggling if everyone has their own form, or if something's missing. If OJD does it, it's in the form center. We know it's there. We can provide it to our courts in our county for their use. And then no court is going to have to wonder what's missed, what's not missed, all of those things. I totally support, from a circuit court perspective, one consistent form that OJD can manage.
Lindsay?
I just wanted to follow up on Jim Nass's comment about requiring the litigants to use it. I noticed down in subsection B of this same section that we're talking about, it says the clerk of the justice court shall provide to a party at the party's request the form of notice of appeal that substantially complies. So there could be a directive for the court to provide the standard statewide form that's created by OJD. And so that would result probably in most litigants using it without creating a requirement that they use it.
All right, well, just this Brisbane.
Okay. I agree with Lindsay's comments. I just want to remind everyone that 99% of the people that we're talking about are going to be pro se appellants, and that's why there's an importance to have a form. The lawyers are going to draft their own form that's going to be substantially the same on their letterhead or their pleading paper. But for the most part, for violation appeals and small claims appeals, we're talking about pro se individuals.
So it sounds to me like we're sort of coming to a consensus on providing a mandate in the statute that that OJD create a statewide form and that it be provided to parties at their request. Anybody want to comment on that general idea? Is anyone opposed to, I mean, we've heard some other comments. Is anyone opposed to that idea? Okay, great. I guess then the question is, what sort of detail do we need in the statute about what needs to be in the form, and that maybe could go along with whatever we're doing in the main section about all the other types of cases. And I don't remember actually what it says at this point, but is there any reason that small claims would need to be different from what we're doing with the rest of them? Okay, any objections to just incorporating what we're doing in the main portion of the working draft 3 as far as the notice? If you do, how about you can email me later if you have a chance to think about it and have an objection. All right, great. What else do we need to talk about in Jim's draft? Is there any other specific language that people wanted to discuss?
Well, I would like to speak to the proposed amendments to ORS 55.130. Much of this section arises from the requirement in Chapter 55 that a justice court create and maintain a docket for the small claims department separate from the justice court generally. Because there are two different dockets, and because execution cannot issue from the judgment in the small claims court docket, there needs to be a process for those judgment creditors who want to execute on a judgment to get the judgment into the regular justice court docket, and then the person could then execute on it. What's odd about this statute, though, is that the current law requires the justice of the peace to certify, in essence, that the small claims court judgment is legitimate and therefore can be entered in the register of the regular justice court. But I'm thinking most justice courts, you have one judge, you have a couple of employees. Why do you need to have the justice of the peace certify the legitimacy of the judgment? Why can't the law just say that upon request of the judgment creditor and payment of this $9 fee, the small claims court judgment will be entered in the register of the regular docket, and then it can be enforced from there?
Justice Kidd?
So why even have that step? Why, if we're drafting the law, why don't we say that the judgments in the small claims cases are automatically executable just as if they came out of the other docket? Right? Like, it seems like, I agree with Jim, it's an antiquated step. It's weird because I move cases from one part of my court to the other as if I was a totally different county. Like writing letters to myself, it's kind of silly. Why don't we just say that they're executable? Why require the $9 fee even?
Justice Cross?
Does that have to do, because when I see those, it tends to be because the judgment creditor wants to essentially register the judgment in the circuit court to, and then they can bring liens into play in terms of the collection process. I don't recall anybody ever making a request for me to do it just within myself like that. May have happened. But it's what I typically see it is when they want to register with the circuit court. And would changing this impact of judgment creditor's ability to do that?
Justice Kidd?
We do. In order to garnish, they have to move out of the small claims docket and into the regular civil docket of the justice court. So right now we do have to move things like from one division to the other within the same court, weirdly. And I propose that there's not a reason for that in this century.
Well, we do move it from the small claims docket to the civil docket, so it gets a new case number,
Mhm.
a civil case number.
And I don't think we should need to have some, I agree, it's kind of seems silly to do it with regard to that for inside the justice court, but what impact would it have on their ability to take it to circuit court? Any? Would we still need the provision and they call it $9, the transcript fee, I think is what it's referred to as, or something, which is not really a transcript, but anyhow, do we need, I don't want to get rid of something if it's still an important tool for judgment creditors in that regard.
Question for you. Does anybody know the history of why justice courts are required to create and maintain a separate docket for small claims court cases? Why not just have one single docket?
That I have no idea about.
Well, we have one docket for small claims cases, but when there's a transcript, we move the case to a civil case to the civil docket. So we have a small claims docket, we have a civil docket, we have a violations docket.
And I guess I'm asking the question, what is the need for a separate small claims court docket?
Well, most cases stay in the small claims docket and never move to the civil docket. We could probably find out from a retired justice of the peace that might have more history. Even though we've been around for several years, these are older statutes than any of us.
And probably, since our mandate is to deal with appellate stuff, it probably goes beyond our mandate to mess around with that kind of detail. So I'm leaning towards obviously leaving the small claims court docket, but I like Judge Kidd's idea that upon request of the plaintiff or whoever the judgment creditor is, that the judgment be entered in the register of the regular civil court and go from there and eliminate this certification process.
Justice Duncan?
I don't know the history of this provision, but it does seem to have a step that just has to be, there seems to be a determination that the payment hasn't been made because it requires a determination that the party has failed to pay the judgment according to the terms and conditions thereof. So maybe you stay in the small claims court until there's a failure, and at the point there's a failure, then you can get the case moved over to the civil docket. I don't know, that's just based on the plain text of the statute, but I agree with Jim that we should be that doing anything that would affect how these cases currently move from small claims to civils, probably beyond the scope of this work group.
Well, also in 55130, down in subsection 2, there's a suggestion that the language transcript on the docket and the transcripts of judgments be eliminated. But if we do that, there are other statutes that we would have to change, because if you look at OJD's fee schedule, 21 ORS 21.235 subsection 1A, and also refers to ORS 52.635 subsection 6, which is a justice court statute, all refer to transcript of judgment. If we take that out, we have to look at many more statutes than just 55130.
Okay, do we have a proposal to change the language that Jim's proposed, or retain it, or what are we looking at here?
What is a transcript of judgment? What is it? What does it look like?
Justice Kidd?
It's literally a letter that I write myself that says there came in the small claims division this case. And if the case has not been paid yet, so far as I know, so it's still valid, right? So I can do a transcription of judgment from my court to downtown if people want to put a lien on real estate, which is fine. But in order to do a garnishment, it has to move from one division to another. And so it's really like literally a letter I write myself and then I sign.
But if someone wanted to register a judgment of the civil, in a civil case of a justice court to circuit court, would they send along a copy of the judgment so that the circuit court clerk would have the information to create it?
No, what circuit court gets is a letter from me saying on date X, there was a trial and I found that this amount was owing and it hasn't been paid as far as I know. That is what creates the circuit court case that Linda gets. And Linda, I don't know what you do with it, but that's what I send.
Jim, we have a prefab document here that my clerk does, and then I sign it, the clerk signs it, and which contains essentially the language in a little more arcane style than what Justice Kidd was talking about. And then we do, I believe, send a copy of the judgment, actual judgment over with that document. I don't know if that's required or not, but that's what we do.
Okay, but I think the point having been made that the word transcript of judgment appears in other statutes, I think persuades me that we should retain that language here, even though I think it's kind of antiquated. I think it goes beyond what our scope is to start messing around with all those other statutes.
Justice Brisbane?
When we're done with that, could we go back up on the document to 55120?
Yeah, I think sounds like we had consensus to retain the original language about, and is that in subsection 2? Let's see. 55-130 sub 2. Jim, you were talking about retaining, not making the change that you were talking about there in your draft. Is that correct?
Yeah, I think the only change that we'd end up making is replacing the word docket with the word register. Because I think what the main bill does is rename that thing from a docket to a register.
Okay, any other comments on that before we move on?
I thought there was also a proposal to get rid of the certification and just have a transfer on request.
Yeah, although I think Justice Duncan makes the point that a key part of the certification is that the judgment has not been paid. But of course, the justice of the peace has no way to know that. So I think what we should rephrase this is that the judgment creditor who is seeking to transfer the judgment elsewhere would certify that the judgment has not been paid. But so the judgment creditor's certification would take the place of the justice of the peace's certification.
Any further comments on that? Okay, is that clear then what we're doing here, or do we need to follow up on that?
I guess I'm still a little confused just from a drafting perspective. So like according to this draft, it's still the justice that is doing the certification. So are we going to switch to this process where it's the judgment creditors certifying that there hasn't been payment, and then they make the request to the court to transfer the judgment to the regular civil department or the civil docket? that would be a change
That's-
from what is proposed here. I just want to confirm.
That's what my vision is, yes.
Anyone who wants to comment on that? Justice Cross?
And then how does that impact those other statutes that Judge Brisbane was talking about? We'd have to take a look at all those and make sure that there's not gonna be any issue created in those other statutes.
Yeah, I think we need
Just
some
seem-
time to
just-
go back and look at those.
Yeah, it just seems like we're still opening a can of worms. I don't think we need to be opening for what we're tasked to do.
Is there a need for this change? I guess we have 2 minutes left. So
I
maybe-
can do mine in 30 seconds. or
okay,
less.
go for it.
Okay, up the document in 55.120 subsection 4, it says if the circuit court dismisses the appeal or affirms the justice court's judgment, the appellant shall pay an attorney fee in the sum of $10. I don't think that all that section is not needed, in my opinion. First of all, there's no attorneys. And I guess that means if the parties consulted with an attorney before they filed their case, they could be reimbursed $10. I don't know. I don't think it's needed anymore.
I would just point out that I took that wording from ORS 55.110 what is now subsection 1, the last sentence. I absolutely agree that this whole concept of an attorney fee in the amount of $10 is archaic, but I didn't want to mess with it. It's a requirement of current law that I was just moving to a different section.
Right. I agree that that's what you did, Jim, but I also agree that it's no longer needed.
Is anyone opposed to removing that? Okay, I think that sounds like a consensus decision. So I don't know if there's anything else in this that we needed to discuss. We are out of time. How about if folks email me if there's any other items on this that you need to discuss? And I guess we didn't quite resolve the previous question. So let's figure out what the remaining questions are and maybe we can resolve those easily. We also have the fees issue update that was just sent around. And so folks can take a look at that and see if you have comments. We will put together the agenda for the next meeting, which is July 10th. Is that correctly?
July 10th.
So as soon as we can, we'll try to put that together, and it would really help if everyone emails in any outstanding questions or comments on other questions that we've put out there ahead of time, so we can get the best idea possible of what we need to spend the time on. Any other questions about what we're doing here before we get off? Okay, thank you all so much. We'll see you next time.